Good evening and welcome to another lecture series for the preparation of CLAT examination 2023. This lecture series we are talking about the competitive examination preparation for CLAT examination. Apart from this particular lecture series, we are focused over providing education in regards to the legal fraternity, how the different laws are being governed in the society. We have been discussing about all the important laws that has to be dealt with whenever we are talking about examinations, competitive examinations, specifically CLAT, ALIT, and all the examinations which are linked towards the law fraternity. In this particular lecture series, we have been focusing over a particular area of legal reasoning in our CLAT examination that is often asked, and that is also the part of the syllabus of CLAT examination. In this particular lecture series, we have till now talked about some of the important aspects of law. We have covered legislations like the Indian Contract Act 1872, which talks about the different agreements that takes place within the individuals and the organizations in day-to-day life, and how to tackle those agreements, what are the essential requirements, and how to prepare those agreements, what are the requisites that a one person should keep in mind whenever they are preparing such agreements. Apart from that, we have talked about the criminal law. We have talked about the Indian Penal Code, the code which defines the different offenses that can be used to punish any offender who has done that particular offense. For example, for instance, if see that somebody has murdered someone, or killed someone, so IPC, Indian Penal Code 1860, specifically it defines murder as killing of somebody, as killing of human with the intention of killing that person under section 302. So we have discussed all the major offenses that might be asked in your CLAT competitive examination, or which are actually important. And after that, we have resorted to the main source of all the legislations. We were talking about the fundamental rights. We are talking about the Constitution of India. So when we talk about the Constitution of India, we have till now in our previous lecture, we have talked about the preamble that is considered to be the key of the understanding as to what exactly is the need for creating such legislations. As you already know that on 26th of November 1949, we, the people of India, has adopted, enacted and given to ourselves these constitutions. We have accepted and we have promised to abide by the rules and regulations of this particular constitution, and perhaps that is the reason this particular subject becomes a very important point of discussion for CLAT aspirants also, because it is not only the layman who should be knowing that what are their laws and what are their rights and what are their obligations and what are their duties, but it becomes perhaps very important for any member of the law fraternity to be well acquainted by these rights and obligations and the laws. So initially, in the previous video, we have talked about the preamble in detail. We have talked about that how the preamble is considered to be the key for opening the minds of the constitution makers. As we have already discussed, that that Constituent Assembly under the chairmanship of Dr. B.R. Ambedkar had taken 2 years, 11 months, and 18 days to prepare this legislation, the Constitution of India, and it provides us with the detailed framework as to how the government will work. What will be the rights of the individuals? What will be the rights of the citizens? What will be their obligations, or rather, I would say, the duties of the citizens? And we will also come to know that the Constitution of India also describes about the different directives or directive principles which are being given to the government whenever they are framing policies for the betterment of the society. In this lecture series, we are going to discuss about one of the most important and major aspect of fundamental rights. As you know that fundamental rights, if the name suggests, are those rights which are fundamental in nature. And if you talk about the very beginning of this particular rights that are given to the citizens, we'll find mention of in the year 1613, we find mention of the Bill of Rights. Bill of Rights was perhaps for the first time we saw that the citizens or the nation, the nationals or the individuals should be given a basic set of rights for their all-round development. It included right to shelter, right to life, and various other fundamental requirements. In the same way that various nations have accepted and adopted the fundamental rights, India has also incorporated fundamental rights as the rights that are given to the citizens in the Constitution of India. When we talk about where the fundamental rights has been mentioned in the Constitution, we find reference of fundamental rights under Part 3 of the Constitution. In our previous video, we have discussed that there are perhaps more than 24 parts under the Constitution and more than 448 articles along with 12 schedules, which comprises the majority of the Constitution. The Constitution has been amended. Amendment means that it has been altered and changed according to the needs of the society, which makes it a very dynamic legislation. And in the same way, in the same manner, the fundamental rights has been incorporated in the Constitution to make sure that the citizens are developing and there is all-round development of the citizens. If there is any right which is being infringed by any of the individuals or any of the state employees or anybody, these fundamental rights, the person can claim remedies by the courts by asking them to reinforce their fundamental rights. So first and foremost, before we understand what exactly is fundamental rights, first we will have to understand that against whom these rights are given. But before studying that also, we will be focusing our mind and we will be first understand the duties that has been mentioned under Part 4A of the Constitution of India. Why we need to understand the rights before understanding the fundamental, why do we need to understand the duties before understanding the fundamental rights? The reason being, we need to understand the duties, because once you're acquainted with the duties, it becomes perhaps easier to understand the rights. Because it is often seen that the duties is already mentioned, there are only perhaps 11 duties that a CLAT aspirant has to understand and remember. And these are very small yet important duties. And first we need to understand that when we talk about rights and duties, there is a small difference between their enforcement also. Enforcement. Now, what do you understand by enforcement? Enforcement means that if somebody not abiding by fundamental rights, you can move to the court, because these are your political rights. And political rights are those rights which can be enforced in the court of law. And that when you talk about the fundamental duties, so fundamental duties cannot be enforced in the court of law. Meaning which, that if somebody is not abiding by these duties, or they fail to abide by the duties that is there, they can be guided, because these are the moral duties which is expected from all the citizens, because they should honor the nations as such. But if the people they are unable to fulfill these duties, it is not like that you can move to the court. But this becomes a very important point of discussion when it comes for your CLAT examinations, because majority of the time it has been seen that the invigilator or the examiner, while preparing for this particular examination, will make sure that those areas which is considered to be very simple, yet it can be transformed into a complicated factual situation, will be put in front of you. The questions will be in such a manner that there will be a narration of a story, and in that particular narration it will be mentioned that XYZ didn't follow the duty that has been incorporated under part 4a of the constitution under 51a of the under article 51a of the constitution. And you will be asked that whether the person will be charged or whether the person can be stand accused and can he be tried against in the court of law. The question specifically asks whether the fundamental duties can be enforced in the court of law or not. So once you have the thorough knowledge that fundamental duties as such cannot be enforced, it becomes a clear understanding that the answer that has to be marked in your CLAT examination should be negative, not supporting the claims that yes, the person should be tried inside the court of law. The reason being, as I've just informed you, that since fundamental duties are considered to be economic duties, just like directive principles of state policy, and directive principles of state policies are nothing but government guidelines. So it is the guidelines which is given to the government by virtue of by the Constitution of India in regards to that whenever there is a formation of policy by the government, they have to make sure that they are abiding by the policies that has been incorporated under the Constitution under part 4 of the Constitution, which talks about directive principles of state policy. But as of now, in this particular lecture series, we will be confining ourselves to the fundamental rights and the duties. And post completion of fundamental rights and duties, we will have a quick glance over the directive principles of state policy. As I've again informed you that the directive principles of state policy are not enforceable just like the fundamental duties, but these act as the guidelines which the government is much more morally obligated to follow. And even if they are not following it, it can be considered as not adhering to the principles of natural justice. And this is something obviously we might be dealing in some another lecture, because it will obviously be going into a different path. So let's confine ourselves to the study of the fundamental rights and the duties. As you can see the screen, as I've told you that we're going to study the duties first, and then rather we will be concentrating ourselves towards, we will be initially understanding the fundamental duties first. The reason for understanding duties are there are only 11 in number, and it will be easier for you to grasp these fundamental duties and how to remember them and how to make sure that you are retaining it during your competitive examination is perhaps the most essential point to be noted and to be remembered while studying fundamental duties. So the first thing that you need to understand is that how many numbers are there. So there are perhaps only 11 fundamental duties that one needs to remember. Initially, there were only 10 fundamental duties. But after the 86th amendment, after the 86th amendment, 11 fundamental duty was also added in part 4a, that is your fundamental duties part of the Constitution. Article 51a, part 4 of the Constitution of India provides a detailed framework of the fundamental duties. Initially, there were only 10 fundamental duties. The first and the foremost duty of every citizen of India is to cherish and follow the noble ideas which inspired our national struggle for freedom. So this is obviously one has to remember and make sure that they are following the noble ideas, the principles and the policies which were given by our ancestors during the national movement struggle, whether be it Mahatma Gandhi, whether be it Bhagat Singh, all these national laureates who have given their life and their struggle towards the freedom of the nation should be respected. And it is perhaps the reason whenever you go to the government organizations, you will see the photographs of all these legends being portrayed there so that we can remember them and we can respect them and we can cherish their noble ideas. The second duty is to uphold and protect the sovereignty, unity, and integrity of the nation. So the first thing is obviously to cherish the noble ideas, and second is to uphold and protect the sovereignty. Sovereignty we have already explained, that supreme command, and unity is what we call that one should all be united, and integrity of India. That India, although being a union of different states, but still it should be considered to be a one nation. That is the most important portion that we need to understand when we're talking about India's as such. So this is the second fundamental duty, to uphold and protect the sovereignty. So how do we remember this? So what we can do is, either we can take up the first two words of the fundamental duties of every duty that we'll file mention, and we can just remember that. Like for example, we can remember to cherish, and then second can be to uphold, and then in the same way to defend. So to cherish, to uphold, to defend. And then when you'll see the mention of these three words, you will automatically understand that we are talking about fundamental duties. So this is how one can be made or asked to remember these fundamental duties. The reason being why I'm asking you to remember these fundamental duties, because there will be questions which will be telling you that these are the fundamental duties that has been marked under the Constitution of India. Okay, and then there will be another, this will be the principle, and then there will be another assumption that Mr. XYZ was seen disobeying the national flag. What actions can be taken against him for not abiding by the duties that was present in the present in the fundamental duties of the Constitution of India. Since I've just explained it to you that the fundamental duties are not actually enforceable in the court of law, perhaps that is the reason the person who has not accepted and who's not respected at that point of time the national flag, maybe he should have not used it in such a manner which attracts any criminal offense, because you need to understand that disobeying the national flags can amount to offense that has been mentioned in the Indian Penal Code. But let's take an example that there was a case which there were 20-25 people who were gathered for the national anthem, and it was seen that out of those 25 people, there were 2 people who were just standing and they were not reciting the national anthem at that point of time. And it was observed, the matter went to the court, and the court was to decide that whether they have done anything contrary to the duty that has been present under the court of law. It was observed that non-recital of the national anthem does not amount to disrespect of the nation, and it does not takes away or infringes anybody's rights. So there is no offense that has been done. So that is why we need to understand that the question that will be put in front of you will always be showing that the person is accused, and you will be asked to, your mind will be manipulated in such a manner by the examiner that you have to mark answers in favor of punishing that person. But since we now know that the fundamental duties are not enforceable in the court of law, only on the basis of fundamental duties, and I repeat again, only on the basis of adherence to the fundamental duties, nobody can be convicted. Okay, so this is the important portion that you need to remember. So defend the country and render the national services when called upon to do so. To defend the country and render national services when called upon to do so. So this is something, I suppose this has been repeated again. So what we need to understand here is that the fundamental duty says that if the nation wants you to be there to protect it, you should be always present. So this is one more fundamental duty. Then you have a fundamental duty to promote harmony and the spirit of common brotherhood. The common brotherhood means that we should work hand in hand for the progress of not only one single individual, but the society and the community as such. All the people from different linguistic areas, different religion, different race should They renounce the practice in order to make sure that they all are progressing. And to renounce practices derogatory to the dignity of the woman. You might have remembered, you might have heard the word of sati that was earlier in practice, that when the husband used to die, it was a custom that if the wife is alive, wife will be asked to sit in the holy fire, where the husband was to be cremated. So you see that there were atrocities that were derogatory to the dignity of the woman. And that is only one example I have given. There were various atrocities that used to take place. So when the constitution makers made this constitution, they made sure that the woman should be equally respected. And perhaps that is the reason it was incorporated in the form of duties under the fundamental duties, that the practices which are derogatory against the dignity of the woman should be abolished. In the same manner, you have the duty to preserve and value the rich heritage of our composed culture. You know that India follows a diverse culture where in the northern areas you will find dominance of celebrations on the festive areas. We talk about Diwali, we talk about Holi, and then there is different rituals and different values altogether when we go to the another portion of India, whether be it south, whether be it east, whether be it west. So in altogether we have a diverse culture, and each and every community has a different culture when it gets comparison to. So what we need to make sure is that whatsoever the cultures and the customs the people of the nations are following, we should value and preserve the rich heritage. We should not be westernized, we should not be globalized, but we should respect and we should make sure that there is a separate identity of India being visible throughout the world. And that is why this particular duty has been incorporated under the fundamental duties. And now, obviously, you should be aware that we are suffering from a global warming, and that is perhaps the reason where we have to make sure that we are protecting the forests, lakes, rivers, wildlife, and to have a compassion for the living creations. Because once this, particularly the living areas or the areas which are going to adversely affect if they are not protected, then it is going to affect the citizens only. So that is why it becomes very important that we are protecting and improving the natural environment as such. To develop the scientific temper and humanization in the spirit of inquiry and reform, we should endeavor to work in such a manner that we are progressing in the society and we have developed a scientific temper. We are not we are not dependent, and we do not only have a strong inclination towards the beliefs that we have, but we should work in such a manner that we have logic and sense with doing any work that we are supposed to do. So that is why it is needed that we develop a scientific temper, humanism, that we don't indulge in any activities which is inhuman, and spirit of inquiry and reform, that if we need that there should be any reform that is needed in the society and the community where the practices which we feel are not up to the mark, we should endeavor to reform those practices. And obviously public property, and to abjure violence, we should not indulge and condemn violence. We should condemn violence and we should safeguard the public property. So these are some of the rights, some of the duties that one has to ensure. Then the fundamental duties also talks about to strive towards excellence in all spheres of individuals and collective activities, so that the nation constantly rise and to higher levels of endeavor and achievements. So we work progressively. That is the main crux of this particular duty. And the 11th, till this, it was already incorporated in the year 1949, when on 26th of November 1949, we adopted, enacted, and gave into ourselves this constitution. All these fundamental duties were actually present and they came to force at that point of time itself. But when in the year of 2002, it was observed by a committee that was formulated to show that, to understand that what exactly is the growth of education in the different sectors of the nation, it was observed that there is a dire need to make sure that the education system is provided to each and every sector of the society. And perhaps that is the reason that under the fundamental duties, one more fundamental duty was added, which was under the Article 51A, new clause K, by the 86th Amendment in the year 2002 was added, which stated that whosoever is a parent or guardian to provide opportunities for education to his child, or as the case may be, ward aged between 6 and 14. So it became a duty for the guardian and the parents, and not only to the parents and the guardians, to be frank, it became a duty to the government itself to make sure that every child is getting education opportunities throughout the nation. So these were the 11 fundamental duties that one has to understand, and one has to make sure that they recall and they remember when they are going to sit for the examinations. Because out of these fundamental duties, there are high chances that one fundamental duties will be in a factual form given to you, and it is important and it is a requisite for the candidate to retain those fundamental duties. Because we need to understand that it is not compulsory that every time there will be a concept that will be put forward in front of you. Although the syllabus suggests strong inclination towards a subjective analysis of the law, and that is, there are low chances of you getting questioned directly over the fundamental duties, but it becomes obviously important and requisite that if there will be a question which will be in a factual form related to the fundamental duties, then it is always advisable that the candidate are well versed with these clauses, and they should remember that what exactly and under which clause which fundamental duties has been mentioned. So I suppose that these things have been made clear to you. Now let's move towards the another topic that we are supposed to discuss, as we have just discussed this. And I just like to tell you that this particularly, when we talk about fundamental duties, this portion has been completed. It is under the part 4 of the Constitution of India, and under the Article 51A, it has 11 duties. Earlier there were only 10 duties. One more duty was added. Clause K by the 86th Amendment 2002. So this is the crux and the important discussions that one should remember when whenever this particular question might be put in front of you, that under which amendment compulsory education for the children of the age 6 to 14 was added under the Constitution of India. So this is perhaps something that you need to remember whenever you're talking about fundamental duties. So we have completed the fundamental duties as such, but now we will be focusing and we will be trying to understand another important topic of today's lecture, that is the fundamental rights. So fundamental rights, as the name suggests, that there must be some involvement of some rights. And if I'll tell you, there are specifically 6 rights which we are going to discuss. These 6 rights, initially they were not 6 rights, they were actually 7 rights. But then by the First Amendment, right to property was abolished, and it was made, instead of the fundamental right, a constitutional right. Now, first you need to understand what is the difference between a fundamental right and a constitutional right. Fundamental rights are those rights which are given to the citizens, and it is a derogatory or a requisite that these rights will be entertained, and if they are curtailed by the government or by anybody, then it can be restored by resorting to the court that is present. And perhaps that is the reason the Supreme Court is considered to be the Supreme Court is considered to be the guardian of the fundamental rights. If there is any infringement of the fundamental rights, we can directly resort to the Supreme Court and ask to restore our fundamental rights. But when we talk about constitutional rights, so constitutional rights, there is no such relief where which we can directly resort to the Supreme Court and ask that my constitutional right was infringed, and perhaps it is you who should be taking actions against the same. Apart from that, when we talk about the restoration of fundamental rights, when we talk about fundamental rights, there is another word which is known as writs. Writs. So these writs help us in the restoration of the fundamental rights. So this is something that also we are going to discuss in our in the ongoing video. So let's first try to understand that there were 6 rights. Let's see what are those 6 rights that are present. So before we move forward and before we understand that what are those 6 rights, or what are the rights that are being given to the citizens, and I am pretty much sure that you people are well aware of those rights, but obviously that this detailed discussion is obviously required. One question that would be obviously coming into your mind, that okay sir, that there are fundamental rights, and these fundamental rights are 6 in number, and they can be, if they are infringed, we can get it restored by resorting to Supreme Court and the High Court. But one question is, against whom? Against whom? Against whom these fundamental, if there is an infringement of the fundamental right, can we get it restored by any way possible, or there is certain requisite? So for that, for understanding in detail the fundamental rights as such, we have to resort to part 3 of the Constitution. So part 3 of the Constitution starts with the Article 12, which talks about the state. And here we are not talking about the state as such, but we state which is India as such, but state which is actually going to be defined under Article 12, which is only confined towards the fundamental rights. So the definition of the state under Article 12 is only in relation to the fundamental rights and nowhere else. So whenever there is any infringement of the fundamental rights, first it is important requisite that we resort to the definition of state and see whether the person who have been accused of taking away or abridging the fundamental rights of any of the citizens, who proclaims that he is the victim and he comes to the court and asks that particular court to provide remedy for the same, the first and the foremost thing the court is supposed to do is to understand that whether the offender against whom this particular policy has been filed falls within the ambit of the state or not. Only against those officials or organizations which falls within the ambit or the state, within the definition of state that has been defined under Article 12, only for those people fundamental rights can be restored. And that is why it becomes a very important discussion to understand that what exactly is state according to Article 12, against whom we can get our fundamental rights restored. If we talk about Article 12, Article 12 as such has been defined under Part 3, which says that unless the context or otherwise requires, okay, unless the context otherwise requires, the state includes. So what the state will include? The government and the Parliament of India. This is the first point. So there will be a government plus Parliament. This is your first equivalent. Second, what does it say? And the government and the legislatures of each of the state. So the second one would be the government plus legislatures of each state. And as you know, that parliament is also nothing but it is a combination of legislature plus executive. It comprises of two houses, one being the Lok Sabha and other being the Rajya Sabha, and along with executive head, that is the president. Okay, so these are the two things that has been understood. And also state includes all local or other authorities within the territory of India. So the third point is local authorities, and the fourth one is other authorities. So as we can understand that the first point says that the government plus parliament, and we already know that what exactly is parliament. Parliament is nothing but it is a comprised form of the Lok Sabha, the Rajya Sabha, and the presiding officer, that is president. When we talk about the government as such comprises of the executives, the cabinet ministers, the prime ministers, and the president as the head of the state. In the same way, that is what we are talking about at the central level. So if I give you an example, the government that has been formed by the ruling party, which is being headed by the Prime Minister Modi, is the government which we have to consider here in the first point, along with the parliament where which both the Lok Sabha and the Rajya Sabha are present, where which you find mentions of the different sessions, where we see the winter session, the monsoon session, all the discussions, all the debates between the ministerials, candidates, and how we are going to frame the nations, what will be the policies, each and everything is being done at the central level in the parliament itself. When it comes to state, then we are talking about the legislatures of each state. We are talking about the legislative assembly and the legislative councils. In Uttar Pradesh, as you know, that there are both the things available. Legislative council is also there, legislative assembly is also there. But there are various states where you won't find mention of legislative council, and that is why if you see here, the important requisite of Article 12 says that it is the legislatures of each of the state. So here we are talking about the legislatures, the lawmaking body, the lawmaking organ of the government. The lawmaking organ of the government both at state level. State means here Uttar Pradesh, Madhya Pradesh, etc. Plus at central level. Both comes under the definition of state. Meaning which, if there is any officials or any policies or any framework of the government, whether it be the state government or whether it be the central government, which is abridging or taking away your fundamental rights, you are within the capacity to resort to the Supreme Court and the High Court and ask them to proclaim any order so that your fundamental rights can be restored. Then apart from that, we find mention of the local authorities. Now, in order to understand that what all exactly will constitute the local authorities, one has to resort to the definition where we would find the mention of local authorities. So it is important and it is worthy to understand that what exactly legislation which legislation is going to provide definition of local authorities. This is a question that will be put. So if we see the local authorities, if we see the definition of authorities only, what is an authority? So an authority is a person or bodies of persons authorized to make rules or laws. So the authorities means a person or bodies of person authorized to make rules and laws. And when we talk about the local authorities, all those persons or bodies of persons authorized to make rules or laws for the local area is nothing but local authorities. So this is a definition for the layman. But what does the law says? The law defines local authorities under the General Clauses Act. So this is a separate act that is there which defines some general terms and conditions which will make you out there and understand that what are the general terms that might be used in the different legislations. So under section 3, subsection 3 is of what? Of the General Clauses Act. Please remember, we are not talking about the Constitution of India here, but rather we are talking about the General Clauses Act. So the General Clauses Act under section 3 of the General Clauses Act 1897, we find mention of the definition. We find mention of the definition of the local authorities. So local authorities include municipal committee. So municipal committee is those committee which is responsible to make sure that there is a clean and hygienic society where which all the important requisites, whether be it electricity, whether be it water, whether be it cleanage and drainage, with everything which is reliable over a municipal corporation is under the definition of municipal committee. Then you have the district boards, whether be it the electricity board, whether be it the water board at the district level, all these comes under the local authorities. Then the body of ports and commissioners also are defined under the local authorities. So I suppose we are well understood that under the part 3 of the Constitution, the state, which obviously if there is any infringement of fundamental rights by any of these members or the makers or the organizations, then we can resort to the court to get our fundamental rights restored. So we have understood what exactly is the government and the parliament at the center. I wish you the very best of luck. Let's meet in the next video. Bye-bye. Take care.